This is A.
Yes, hello.
We can start now.
Excellent. Okay, I welcome us all to the Laciac Live Debates 4th edition. It's a great privilege, a pleasure, and indeed an honor to welcome you. And when we launched the LLD in July of 2020, precisely a year ago now, we had mentioned that our intention is for it to be a continuous process. We're happy that we've been able to live up to this objective, and we have had 3 successful editions in the last year. We're grateful to those who have been with us from the first edition and have provided their continued support and encouragement. If this is your first time, we are very glad to have you join the Laciac Live Debates and hope that you will make it a quarterly habit to join us at this event. For the benefit of those who may be joining us for the first time, the Laciac Live Debates, LLD for short, was launched in July 2020. The debates focus on developing and emerging issues, trends within the international arbitration community and provide a platform for arbitrators and arbitration practitioners to reason and discuss these issues. The LLD has had 3 successful editions, and we're confident that today's edition will equally be as successful as the previous editions have been. We also look forward to the continuous participation of our audience from different regions within and outside of Africa. The current edition is the first to occur in 2021, and more than 300 practitioners, including practitioners from different regions in Africa and Europe, have registered their interest to attend the event. Opening remarks is called, so I'll just stop here and allow today's agenda to run its course. And I'll start the ball rolling by introducing our brilliant moderator for this edition, Ilham A. Kaburi. Ilham, sorry, I just need to work around this thing. Well, Ilham is the senior associate. Excuse me, please. Ilham Kaburi is an associate at Hogan Lovells. She acts for state-owned and private entities and is experienced in both high-value arbitrations, spanning multiple jurisdictions and litigation cases before the English courts and the UAE common law courts in the Dubai International Financial Center and the Abu Dhabi Global Market. She has represented clients in proceedings administered by the ICC, the DIAC, and GCC. A key member of the Hogan Lovells Africa practice, Ilham is active in the development of arbitration in Africa and has assisted a number of African governments with the creation and improvement of their arbitration legal framework. In 2020, she was recognized by the Association of Young Arbitrators as one of Africa's 50 most promising young arbitration practitioners. She's described as being a strong advocate for diversity. Ilham is a member of the firm's, that's Hogan Lovells, Steering Committee for Women in Arbitration. She's a member of the Africa Subcommittee of the Equal Representation in Arbitration Pledge, and is often a featured speaker on ethnic and gender diversity issues at arbitration conferences around the world. Distinguished ladies and gentlemen, I present to you our moderator today in the person of Ilham A. Kaburi. Ilham, you're welcome, and thank you.
Thank you. Thank you for the kind introduction, Mrs. Akeredolu. As a young African practitioner, I must first say that I'm very honored to have been invited to moderate a debate between 2 giants of the arbitration community in Africa, Professor Konina Jai and John Ohaga, whom I will introduce in a minute. Before I go on to present the motion for this debate, ground rules for the event, and more importantly, our debaters, I would like to first thank the Laciac team for organizing this fantastic event. Among others, Mrs. Akeredolu, Dr. Ajibade, Mrs. Silmia Detona. Thanks for all the hard work in putting this together and bringing us together. And I would also like to thank my dear friend Abayomi Okubote for recommending me as moderator for this event. I have 2 very difficult tasks in introducing this event. First, I need to introduce the motion, and I have promised to summarize the Halliburton and CHUBB case in less than 5 minutes, which is quite the challenge. And second, I need to introduce those 2 pillars of the arbitration community also in a couple of minutes. So let's get on with that. As you know, the motion today is arbitrators' duty to disclose African jurisdictions should follow the principles in Halliburton and CHUBB. Halliburton and CHUBB is a decision that was handed down by the United Kingdom Supreme Court in November 2020. It is a case that is relevant to appointment of arbitrators as it dealt with issues of impartiality and apparent bias. The case concerned the very specific situation where you have an arbitrator being appointed in multiple arbitrations which have the same or overlapping subject matter, meaning they arise out of the same incident or facts, and there is one party common to those arbitrations. The main question that was before the Supreme Court was whether, in such a situation, there is apparent bias or impartiality by the arbitrator. Apparent bias in that context was taken to mean that the acceptance of an appointment as an arbitrator in such circumstances gives one party a procedural advantage. Why a procedural advantage there? Because one party has access to that arbitrator's responses to evidence, to arguments in one arbitration before it can deploy those in the other arbitration with the party, which is not common to both arbitrations. As time does not permit here, I will not go into the details of the background of the case, nor will I cover the findings of the High Court and the Court of Appeal. I will limit myself to briefly presenting the background and outlining the key principles in the Supreme Court decision, which we are discussing today, as to whether they should be applied in African jurisdictions or not. Briefly on the background, in April 2010, one of the largest marine oil spill in history happened in the Gulf of Mexico. That led to vast property damage, and that also led to claims between the owner of the rig, Transocean, the provider of well cementing services on the rig, Halliburton, and Halliburton's insurer, CHUBB. In an arbitration between Halliburton and its insurer, CHUBB, CHUBB nominated an English QC as co-arbitrator. That QC disclosed he had previously been nominated by CHUBB in other arbitrations. That element, however, of the disclosures did not give rise to objections by Halliburton. Later on, however, that same QC was nominated on 2 arbitrations relating to the same oil spill incident involving the rig owner, Transocean, and CHUBB. Although the QC disclosed his appointment in the Halliburton case, in the context of his nomination in the 2 later arbitrations, he didn't go back to Halliburton and disclose those further appointments. When Halliburton found out, they sought to have the QC removed by the High Court for lack of impartiality and apparent bias. The High Court and then the Court of Appeal rejected Halliburton's application, and Halliburton appealed to the Supreme Court. The Supreme Court dismissed Halliburton's appeal to remove the court-appointed arbitrator, holding that there was no apparent bias and therefore no grounds to remove the arbitrator. The main issues before the Supreme Court, in respect of which we are considering whether those principles ought to apply in African jurisdictions today, are twofold. Question 1 was whether there are circumstances in which an arbitrator's acceptance of appointments in multiple arbitral references involving a common party and the same or overlapping subject matter would, without more, give rise to an appearance of bias. On that question, the Supreme Court concluded it may be the case. Such circumstances may give rise to an appearance of bias. However, such assessment will depend on the facts of the case, the terms of the arbitration clause, and the customs and practices in the relevant field of arbitration. The court held that depending on the subject matter fields of arbitration, parties will have different expectations as to the degree of an arbitrator's independence, but also different views as to the benefits to be gained by having an arbitrator who is involved in multiple related arbitrations. For example, interrelated arbitrations are not common under the auspices of the ICC, but the same cannot be said for GAFTA or LMAA arbitrations, where the fact that there was multiple appointments might not be considered by itself as giving rise to an appearance of bias. The second question was whether and to what extent an arbitrator can accept such appointments without disclosing them. In that respect, the Supreme Court held the starting point is that arbitrators have a legal duty to disclose facts and circumstances which would or might reasonably give rise to an appearance of bias. The fact that an arbitrator has accepted multiple appointments in multiple arbitrations concerning the same or overlapping subject matter with only one common party is a matter which again may have to be disclosed, depending on the circumstances I outlined earlier. Again here, the court held that whether an arbitrator needs to make disclosure will depend on the customs and practices in the relevant field of arbitration. Lord Hodge held that in cases where disclosure is called for, the acceptance of those appointments and the failure by the arbitrator to disclose the appointments taken in combination might well give rise to the appearance of bias. This closes my short summary on the principles of the Halliburton and CHUBB case. And we will now discuss whether they ought to be applied in African jurisdictions. That's what the debate is about today. The debate will take 40 to 45 minutes. Each side will have 15 minutes for the main arguments and then an additional 5 minutes each for rebuttals and sub-rebuttals. The Chatham rules apply. The arguments presented by the debaters do not necessarily reflect their own views on the motion. Once the debaters present the motion, the opposition, and the rebuttals, there will be no interruption for comments or questions. However, I will be monitoring the chat and the Q&A function option on Zoom during the debate. So I do encourage you to submit questions during the debate as we have allocated 10 to 15 minutes for Q&A at the end. So participants, you have 3 tasks today. Listen, keep an open mind, and see whether you can be persuaded either way by our debaters. Drop your questions and comments in the chat function, if any. And the last one is, I'll be grateful if you could participate in the polls. We will have 2 polls, one before the debate, where we will ask you whether you agree or you disagree with the motion, and the same one at the end of the debate to see whether the debaters have swayed you either way. But before I ask you to vote, let me introduce our debaters. Proposing the motion is Mr. John Ohaga. Titilope, can you pull Mr. Ohaga's bio on the screen, please? Mr. Ohaga, Senior Counsel, which is the highest level of professional recognition for Kenyan lawyers, is the managing partner at Triple OK Law LLP Kenya. With over 30 years experience, he has been involved in numerous complex and high-value litigation and arbitrations, both domestic and international, and both as counsel and as arbitrator. He regularly advises blue chip companies listed on the Nairobi Stock Exchange, private companies, and some of Kenya's largest state corporations. He sits on the board of several companies and public tribunals. As a litigator, Mr. Ohaga represents clients regularly before the Kenyan courts at all levels and has provided expert opinions and appeared as an expert witness on Kenyan law issues before the courts of England and Wales and in the United States. He has been consistently recognized for his high-quality work and expertise in dispute resolution, including in Legal 500, Chambers Global, and Best Lawyers ranking. Opposing the motion is Professor Conin Ajayi. Professor Ajayi is a leading senior advocate of Nigeria, a very prestigious rank in Nigeria, and the managing partner at Olaniwu Ajayi LP. With over 40 years experience advising corporates, multinationals, and governments in several sectors of the Nigerian economy, Professor Ajayi is described as one of the best in Nigeria. He has vast experience in both transactional work and dispute resolution, including commercial and investment disputes. Professor Ajayi is recognized as a leading individual by Chambers Global and is ranked as highly regarded by IFLR 1000. Professor Ajayi is admitted to practice in both Nigeria and at the English bar. We will now go straight to the poll. So the question that will be asked to you participants is whether you agree or disagree with the motion. And you also have those two extra options I didn't know about, of not strictly or not sure. So I'll give you 1 minute to vote.
Well, that's poll one.
And we now close the poll and see the results. So 38% yes, 9% no, 38% not strictly, and 16% undecisive. So Professor Jai, you have quite the work today to persuade the remainder of the audience to maybe agree with the opposition. But first, let's hear from Mr. Ohaga on the motion. Mr. Ohaga, the floor is yours. It is now 4:23 in Nairobi. You have 15 minutes. That's taking us to 4:40.
Thank you very much, Ilham. Thank you for that introduction. And thank you to Laciac for the invitation to debate this motion this afternoon. Perhaps the first disclosure I should have asked for was the basis on which I was picked to debate Professor Ajayi, because no disclosure was made to me. And that was an oversight on my part. I really should have started this debate with seeking disclosure a month ago. Having said that, I really am looking forward to listening to Professor Ajayi's views, because it seems to me self-evident that the motion should be carried even before I embark on what I have to say. So as I only have 15 minutes, let me just delve very quickly into it. And I hope at the end of that period, I will have persuaded you to increase the percentage of votes in favor of the motion. Let me start by observing that it has been said that an arbitration cannot rise above the quality of the arbitrator. And whilst that was said in the context of the experience, the expertise, the case management ability of the arbitrator, I think it extends and is true for the arbitrator in the sense of his honesty and willingness to make disclosure at the very outset of the contractual relationship that the arbitrator enters into with the parties when he is appointed, either party appointed or appointed by an institution. And the obligation to disclose is not one that is unique to England and Wales, from which this case arises. It is really a universal obligation. And as Lady Arden said in her decision, in which she agreed with Lord Hodge, the requirement for disclosure is actually a secondary requirement. The primary duty is one of impartiality and fairness. And so when I speak about the quality of the arbitrator and the arbitration not rising, being able to rise above the quality of the arbitrator, what I'm speaking about is from the outset, do the parties have the confidence that the arbitrator that has been selected either by themselves or by an institution is one who takes his place, his decision-making place with honesty and integrity, because disclosure relates to matters which are known to the arbitrator and which would otherwise impede the arbitrator's ability, conscious or unconscious, to decide the matter in a manner that is impartial. So let me start firstly with the duty of impartiality, because as I said, that is the primary duty. The duty of impartiality relates not just to the outcome of the arbitration, but it relates to the manner in which the arbitration is conducted from the outset. And so therefore, it has been said that this is a cardinal duty of the arbitrator. And so therefore, it is a test which relates both to his impartiality, both in terms of the manner in which he presents it himself and the manner in which he is perceived by the parties. And that perception may depend on what the parties know at the outset and what the parties come to know in the course of the arbitration. And so just staying with the facts and the principles enunciated by Lord Hodge, he speaks about the differences between judicial decision-making and the decision-making by an arbitrator. And there are significant differences which you would need to take into consideration when you view the duty imposed on an arbitrator to be impartial. With a judge, as you well know, many times you really have no choice about the judge that you appear before. A judge is paid out of funds provided by the state. A judge has tenure, security of tenure in many cases. And you accept the decision of a judge on the basis that you can appeal that decision to whatever levels of appeal are allowed within your jurisdiction. With an arbitrator, on the other hand, an arbitrator's relationship with the parties is contractual, as I have already said. When you consider that it is contractual, you will see then that there are responsibilities of honesty and fairness which are imposed on the arbitrator as a private person, rendering a quasi-state or quasi-judicial service. The arbitrator has a financial interest in the arbitration because he is paid by the parties to decide or determine their dispute. The arbitrator is selected by the parties on the basis that they believe, or they would like to believe, that he will be impartial in the manner in which he determines a dispute. And so when you consider the two differences, and especially when you consider that there are very limited rights of appeal and review of an arbitrator's decision. And I often think about an arbitration as a pyramid, starting from the bottom, where you select your arbitrator and you're able to present your facts. And the funnel just gets thinner and thinner as you go up, because the rights of challenge get narrower and narrower. And so there is a higher threshold, in my view, placed on an arbitrator with respect to impartiality, for the reason that an arbitrator approaching his appointment cynically is one that can do great damage to the parties as well as to the public trust imposed on arbitrators as a forum for decision-making. So therefore, that brings me to the question of disclosure. Disclosure is, as I've already said, is a product of honesty and conscious thought in the way that you approach your responsibility and role as an arbitrator. If you suppress information which is known to you and which could potentially impact your decision, you are essentially dishonest, and you have therefore approached your contractual relationship and obligations in a dishonest manner. Certainly, there are situations where the lack of disclosure may be innocent, and I accept that. But in most cases, in many cases, in my view, an arbitrator should give thought to the manner, to the nature of the arbitration, the subject matter, the identity of the parties, counsel appearing, and be able to establish by his own investigation and from his own knowledge whether he has any conflict with any of the parties. And that disclosure, therefore, is at the center of the responsibility of an arbitrator. Now, within the context of African jurisdictions, that disclosure, I would suggest, imposes a legal duty on arbitrators in the same way that Lord Hodge found in Halliburton that the duty of disclosure was a legal duty. I would suggest that that duty is a legal duty for the arbitrator within the African context. And this is for the reason that my quick research through the various legislations dealing with arbitration in African jurisdictions demonstrates to me that many forward-thinking African jurisdictions have essentially borrowed the model law and have made that their primary arbitration legislation. And so, for instance, when I looked at the Nigerian Arbitration and Conciliation Act, Section 8 sets out the responsibility of an arbitrator with respect to disclosure. The Kenyan Arbitration Act at Section 13 sets out the same, the duty of disclosure and impartiality. The Ghana Alternative Dispute Resolution Act at Section 15, the International Arbitration Act of South Africa at Section 6. All of these have central to the duty of the arbitrator a legal duty of disclosure. And so therefore, African jurisdictions recognize that disclosure is central. And it really is a question of whether we as African arbitrators want to be considered on the same footing as arbitrators in other jurisdictions, such as England and Wales, Hong Kong, Singapore, and other jurisdictions which have embraced the duty of disclosure and have recognized that they are central to the responsibility of an arbitrator. Having accepted that, then you must then accept that in order for African arbitration to move forward, in order for Africans to believe or to accept that African arbitrators are as good and as competent and honest as arbitrators in the jurisdictions to which we presently export a lot of our arbitrations, we must recognize the centrality of disclosure and we must embrace disclosure. And I would suggest, therefore, that it would be inimical to our ambition as African arbitrators not to recognize the place of disclosure. Now, the question then arises whether disclosure conflicts with the duty of confidentiality. And as was recognized in Halliburton, it does not. Confidentiality certainly is one of the facets of arbitration which is attractive and to which parties subscribe and which is why they come to arbitration. But the duty of disclosure is one that, in fact, in my view, is not undermined in any way by the duty of confidentiality. The duty of disclosure is first and foremost, because it is recognized as a legal duty, one which must be complied with by an arbitrator. Confidentiality is a duty which is not in many jurisdictions set out in statute. It is recognized in principle as something that is central to arbitration, but therefore, I would suggest to you that disclosure ranks higher than confidentiality, and therefore it does not override an arbitrator's duties of privacy and confidentiality to the parties. Now, let me very quickly then move forward to situations where arbitrators have multiple appointments. I have to think through the question whether within the African context, we have situations where arbitrators are likely to have multiple appointments by the same party in factual situations which are similar. And I've not in my research been able to find many of those. And so I would suggest that this is a question of aspiration, because when we talk about aspirations as African arbitrators, we must then think through situations, the possibility that it may well be that in the fullness of time, arbitration is on the same footing as litigation, and that parties come to arbitration on the African continent, looking to arbitrators to make decisions which elevate arbitration and which they can rely on as enabling them to resolve their disputes in a manner that that they think conforms to the facts and the law. So thinking about it from an aspirational perspective, I would suggest to you that it is our responsibility as African arbitrators, and I seem to have run out of time, as African arbitrators who have an aspiration to rise to the levels of English arbitrators, American arbitrators, and so on, to come to the conclusion that where you have multiple appointments, irrespective of the timing of those appointments, that there is an obligation cast on you to disclose to parties the nature of those appointments, the identity of the parties, without necessarily disclosing the subject matter, because obviously there's an obligation of confidentiality that you need to retain as an arbitrator, and which you can protect without impeaching your duty of disclosure. Ilham, I ran out of time, but I know that I will have a right of reply. Thank you very much.
You will, Mr. Haga, and you actually haven't run out of time. It's actually 15 minutes on the dot now. So thank you so much for getting us started and sticking perfectly to time. We will now hear from the opposition. Professor Ajayi, you have the floor. You have 15 minutes, which I think will take us to 5 to 3 in Lagos. Over to
Right.
you.
Ladies and gentlemen, good morning, good afternoon, wherever you are. I realize that my task is tough, tougher than climbing Mount Kilimanjaro, which my brother climbed very easily. As you all know, is from Kenya, and he and his people are great marathon runners. So he's got
Professor Ajayi, sorry to interrupt you, but the audio is not ideal. We can't hear you well. Can you speak again? And you are on mute now. Can the person who has access to the platform unmute Professor
Can you hear
Jaishi?
me now?
Now it's perfect. I'm sorry
Right,
for the interruption. Please
All right,
go
I
ahead.
start again. Ladies and gentlemen, good morning, good afternoon, good evening, wherever you may be, and welcome to this discussion. And it's not a debate. This is a serious matter, which my noble friend has said is a matter of aspiration. But before I get on to it, let me say that I know I have an uphill task before me. I'm asked to climb Mount Kilimanjaro. When from in Nigeria, where I come from, there's no mountain. There are hills, but as you know, Nanet's in our council is from Kenya, and he's a marathon runner. He's been on Mount Kilimanjaro many, many times, and therefore he's got energy and stamina. And most of us believe that our position is what should be supported. But guess what? This is a discussion and not a debate. This is not hypothetical. This is not academic. This is real. This is about expanding the coast of African arbitration, African arbitrators, and African arbitration practitioners. What my friend has suggested we should do is to use a bucket to expand that coast. What I offer you is a dredger that will bring sand in abundance to expand that coast. Now, in doing this, let me also say that what my colleague has done is to go to South Wales, what they call the Cave of Black Springs. It is the deepest cave in the United Kingdom. And he's gone there to look for precedent from the Supreme Court of England. Something that shows you the way we go. In the cave, there is no vision. It is dark and damp and deep. But what I offer you is what he has naturally. And that's what he's offering you. That is the cave he offers you. Thank you, Titi. But what I offer you is what he has naturally. Mount Kilimanjaro. This is where I stand, seeing the whole of Africa and seeing the future. And we can envision, not aspire, but look at the potential of Africa in terms of arbitration. Now, so this is that is what this is about, and not an academic discourse. So what is it that we know? What is it that we should be doing? We know what the judges set that out eloquently before all of them. The interesting thing is that I agree with his propositions because they support what I say. They support the case that we should not engage in any more act of colonization. He said we should try to be as they are in Hong Kong and Singapore when we can be African. He spoke about the bench for African arbitrators. Now, guess what? I am a man of the future, and I'm driven by data and evidence. And what is the evidence? The evidence we have before us is that most of the arbitration that comes to Africa comes by way of reference from law firms and arbitrators abroad. In a report by Redstone Consultants on the African legal market, it says that African firms are highly dependent on referrals from international law firms, and that the African law firm, the African arbitrator, earns just between 10 and 20% of the fees that goes into the arbitration court. So what is it that I'm saying? What I'm saying is this: we should not follow the precedent in the Halliburton case. And I'll tell you why. Essentially, this is what they say. They say these things are the things that are important in coming to a determination on the question of disclosure, confidentiality, and the problem of conflict of interest. And in arriving at that decision, they tell us we should look at a few things. They talk of a fair-minded observer. They speak about reasonable doubt of impartiality, which therefore raises three things, which my brother spoke about. He spoke about circumstance. And therefore, I ask you to look at what the cases say and what our statutes say. Randomly, from Egypt in North Africa, to South Africa in the southern coast, to Kenya in the eastern coast, to Nigeria in the west, to Ivory Coast in the middle, to Niger right up there. What they all say, the cases and the statutes, is that yes, you can even look at what Lady Arden says or what Lord Hodge says, but it must be subject to local circumstances. And what is the local circumstance of African arbitration market? The local circumstance is that there are very few African arbitrators and very few African arbitration practitioners. And therefore, when you look at the reasoning in the Hoffman case, you begin to see the difficulty that the African legal market will face. If you follow the reasoning, not the conclusion is that, well, the arbitrator in that case was not conflicted and the disclosure principles are not breached. But guess what? If you look at the reasoning, which is what we must look at as arbitrators and lawyers, if you look at that, what you would find is that a lot of African arbitrators will be locked out. There are very few of us. And so if I'm not allowed to engage in multiple arbitrations, what will happen to me? Now, one of the most brilliant minds from this continent in international arbitration is Mutabo QC. And he's commented on this in, about 5-6 years ago on the question of conflict of interest and disclosure in the African arbitration market. And he argues eloquently, as he usually does, that we cannot afford to follow the standards that are set in the UK. That in England, the cases are decided based on the conditions of the market. I'll give you a few examples. When the United Kingdom was an empire and controlled the waves, controlled the seas, immunity was important and you could not sue the sovereign anywhere. But when things changed and the empire disappeared and it became more of a commercial state like others, Trendex then came in and they changed the principles on immunity. And that just gives you an example of how these markets operate. You take the United States, look at Wilco and Swan. At a time when the thought securities regulation was very, very important in the United States, the United States Supreme Court said that arbitration could not handle securities regulation. The market moved and they changed the cases. What is our local circumstance? What is the reality of the African market? Ladies and gentlemen, this is what you must think about. You must be driven by data and evidence, not by what you see on the top of the seas. You need to dive deep into the sea to get our reality. And what is our reality? I have told you what the cases have said. And I think I can do no better other than to draw your attention to what the courts here in particular have said, and they echo the sentiments of many African jurisdictions. Justice Toby in Chiboy and Tonimas said it is dangerous to follow a foreign decision simply because its wordings are cognates to our own. My colleague mentioned the laws of Nigeria and Kenya and South Africa and so on, and said they mirror what they have in other countries. Yes, Toby says, yes, the laws may be similar, but it is dangerous to follow a foreign decision on them simply because the wording are cognates to our own. He says our courts are obliged to give what we have the ordinary and natural meaning, taking into account our sociological circumstances as well as other factors which form the background of our local circumstances. A copycat transposition of an English decision may, in the circumstances, turn out to be inimical to justice in our own courts. And this, ladies and gentlemen, is what you must consider. What will be inimical to the things that we do in our nations? In America, we said the same thing in Okonandi State. And this is what I want us to bear in mind. I even then take English decisions and how they say we should interpret contracts. My colleague has mentioned that arbitration is consensual. It's a matter of contract. Yes, it is. What is the principle on interpretation of contracts? I do know better than refer to what he would love to do, English cases. And I refer to Lord Hoffman in Investors' Compensation Scheme and West Bromwich. And it says that when you're interpreting contracts, you cannot afford to be obsequious. You must take the circumstances into account. And that is what we must do when we get to the conference of the waters of disclosure, impartiality, and confidentiality. This is what we must do. And that is what this case stands for. This is what the Supreme Court in Canada, the Supreme Court in South Africa, the Supreme Court in Nigeria have all said. And this is what we must bear in mind. This must be the approach that we take. I ask you, my colleague mentioned beyond aspiration that arbitration is consensual. And it says arbitration is something that must be viewed in that context. He says it is quasi-judicial, but then adds that the arbitrator has an interest in the matter. I dare say that this is not the case. The assumption of the judge who is asked, or the independent party who is asked to look at impartiality, must look at our local circumstance. Our local circumstance is one of trust. We trust each other in our societies, and we give them the benefit of the doubt. Arbitration has been taken in the same way we take customary dealings and customary settlement of disputes. And when we have associations in our societies, and we take a dispute to our local chiefs to settle, the assumption is that they will be honorable and they'll have integrity. And that in spite of the relationship that we have, they will do justice. And this must be what must be seen as driving the appointments that we make. He mentioned that in the interpretation of contract, we must take the circumstances into account. And what are our circumstances? Our circumstances is that we see ourselves as brothers. We trust ourselves, and we ascribe trust and goodness to others. And therefore, in making my appointment of an arbitrator, the assumption is two. One, that the man that I have picked will do justice. But this is the thing that is more important, ladies and gentlemen, that I, the party, am a reasonable person. That I, the party, will not take someone that would subvert the cause of justice. That I, the party choosing, have chosen wisely, and not that I have been unwise in my decision. This, ladies and gentlemen, is what you must think about. What Hoffman and Allen and the rest of them are saying is that I, this independent party that has gone into this contract, that is told that there's autonomy in choice in contract, have not chosen wisely. What the law tells me is that my decisions are things that I must live by. Both of us agreed that we would choose independent parties to decide for us. Both of us are therefore imputed with knowledge to pick the right person. Both of us are imputed with wisdom to do the right thing. And this is what must underline what we do. Another great point to make is this. And I said, that's why I said London Senior Counsel just lays all these points and supports my proposition. He compared the arbitrator to the judge, but then we depart. We depart in a great way because, he says the arbitrator has an interest in the matter. But you may as well say a judge has an interest in the matter because filing fees are paid. After all, the filing fees are paid to the state. It is the state that pays. But what is more important? What is more important is this. We, the public, and he said so. He said so when he was rounding up. He said that there's public trust in arbitration. Yes, there's public trust in arbitration as there's public trust in the judge. Are you saying that because Mrs. Akeredolu, senior advocate of Nigeria, is a very, very litigious woman, who knows every tenant she has because she has many properties, who sues every banker because she has a lot of money and a lot of deposits, who sues every stockbroker because she's got a lot of shares, and who sues every big company because she has a lot of contracts? Are you saying because her cases appear before the commercial judge should be excused? Because after all, when we go before the judge, the fact that the judge determined the case against me in my trespass action does not mean he'll be biased when he's deciding my divorce against my wife. Nor does it mean that he'll be biased when he's taking the shipping case against me. Nor does it mean he'll be biased when he's taking the banking case against me. Now, we have very, very strict rules on disclosure, confidentiality, and partiality when it comes to justice delivery. And what I bring to you is that we must apply the same standards to the arbitrator. So in the way we believe the judge, the test we apply for the judge should be the test that we apply for the arbitrator. Let me begin to round up because I think my time is beginning to run out. And I think this is very important. As I said, for me, ladies and gentlemen, this is not academic. This is not a debate. This is real. This is about expansion of our coast. I thank you for listening. I believe that the audience are wiser now and they will change their vote. Thank you.
Thank you, Professor Ajayi, for the opposition. And before we get to rebuttals, I would like to remind the participants that I am monitoring the chat and the Q&A section. And please feel free to drop comments and questions. We'll pick them up at the end of the event. With that, I will hand the floor back to Mr. Haga to rebut the opposition arguments. And in particular, if I may, tell us whether and why, Mr. Haga, you're trying to lead us to dark caves in Wales. Mr. Haga, as Professor Ajayi ran over with an additional minute, I will give you 6 minutes to rebut, which will take us to 5 in Nairobi, I think. Mr. Haga, over to you.
Thank you very much, Ilham. Thank you. I have to say, very impressive from Professor Ajayi, but unfortunately thin. Professor Ajayi wants to stand at the top of Mount Kilimanjaro and leave the parties at the bottom of the mountain. I had hoped that at the end of his discourse, he would have found an elevator to bring them up to where he was at the top of the mountain, with all the knowledge imbued in him as an arbitrator as to his circumstances, his potential conflicts, his relationship with the parties. What I hear him say is that because of the limitations of the African market, it is not necessary. It is not necessary for us to aspire to a standard that enables us to bring arbitration to the same footing as litigation as a preferred method of dispute resolution. I would suggest, therefore, to you that the reasons put forward by Professor Jai do not cut with me. I do not suggest that arbitrators should not accept repeat appointments. Arbitrators are at liberty to accept repeat appointments. What arbitrators have to acknowledge when they accept repeat appointments is that there is an obligation cast on them to make disclosure to the parties. More often than not, the question of disclosure is not one that is disclosure in relation to a relationship or knowledge or certain other circumstances to both parties. It is in relation to one party. And so therefore, what we have is an uneven playing field because one party the arbitrator has a certain knowledge relating to one party, which the other party is not aware of. And so therefore, I would suggest that, in fact, it is Professor Jai's proposition that takes us through the caves. Without a torch, I saw that he had a torch, and I hope it would light the way to enable us to navigate the dark enclaves of those caves. Unfortunately, the torch is so significantly dimmed that we're unable to see our way forward to the aspirations that I suggest we should be endeavoring to achieve. It is not a question of the construction of contracts. It is not a question of our local circumstances as Africans. Our local circumstances as Africans, first and foremost, point to the fact that our legislation has, in any event, already borrowed from the model law, as I said. The model law is one that is accepted by every signatory to the New York Convention. And so we are on the same footing. We're on the same footing on the basis of our legislative platforms. Why can we then not be on the same footing in our approach, in the principles that we espouse, in the disclosures that we make when we're appointed as arbitrators? Because only then will parties begin to have an acceptance of arbitration on the African continent as, I would suggest to you, the future of dispute resolution. I listened very keenly to Professor Jai, and he made the statement that we trust each other in our societies and we give each other the benefit of the doubt. Do we truly believe that as Africans on this continent, knowing the many things that ail us, both in our political, economic, and social interactions? The truth is, he puts forward a theory that has no founding in reality. And so as arbitrators, as persons who seek to ensure that we can keep our arbitrations on this continent, as persons who acknowledge that for a long time, we have exported our arbitrations, exported them to London, exported them to Paris, to Stockholm, because our governments, because our African parties, because economic players on this continent thought that there was something there that was superior to what we have here. How can we then accept that we should not find a decision such as this one that enables us to elevate ourselves to a place of acceptance, to a place of aspiration, as I say? We must aspire to a place where eventually in the fullness of time, we will be proud of the products that emerges from this continent. Thank you very much, Ilham.
Thank you, Mr. Haga, for again sticking to time, bringing the torch in the cave, and completing your proposition arguments. I will now go to Professor Ajayi for the opposition to wrap up the debate. Professor, you have 5 minutes.
ladies and gentlemen, my brother has stolen from me the way the colonialists stole from Africa. And you must judge this case simply on that basis. We need to be just in what we are doing. A man that steals from someone really has nothing for you to offer. He's a brilliant lawyer, an outstanding senior counsel, and he simply used his erudition and scholarly skills to try to beat us here in Africa. So what is it that he tells us? He tells us that touch is gene, but guess what? Africa will surely rise. And that is what this is about. We've got to be philosophical about this discussion. Absolutely philosophical about this discussion. And let us consider the things he has said. He said, I try to equate arbitration with litigation, but this is not what I do. What I seek to do is to raise the standard of practice in our markets. What I seek to do is to ensure that principles that have been fashioned abroad to meet the circumstances and conditions of a market are not brought in here, hook, line, and sinker. This is a question of impartiality. That is, at the end of the day, what it is all about. And yes, I agree. An impartial person must make necessary. But then is the other level of the tripod, confidentiality, because we speak of disclosure, confidentiality, and impartiality. And the question is this: is there any data on the importance of confidentiality to arbitration in our markets? Is it the case that we want arbitration to be totally secret? Do we go to arbitration because we want it to be secret? Or do we go to arbitration because we believe that to arrive to the doors of justice quicker, cheaper, and in a manner that understands the circumstances of the people? I believe this is what arbitration is all about. And I think that what Lady Aden and the Lodge and all other justice of England have done is that they think that they have cleared the waters. But the more important thing is this: they actually have muddied the waters. They have not cleared it. And that is what must be clear in your mind. This is what must be clear in your mind. That the waters have been muddied, the waters have not been cleared. I end here, and I thank you.
Thank you, Professor Jai. So this closes the debate, and I thank both debaters for taking on the role fully. We'll now move on to the Q&A, and we've received one question, one comment and question that I will read out loud for our debaters. So the attendee submitted a question that's as follows: the motion presupposes that the principles of Halliburton is the full duty to disclose, whilst the question is whether a lesser duty would be acceptable in Africa. The attendee would propose that the principles of Halliburton can only be seen as the minimum requirements for disclosure, and that we should strive to have a greater duty where multiple appointments by either party or a firm of attorneys must be disclosed. And the question is to Mr. Haga. What's your view on this, both in your role as the debater for the proposition and also as practitioner?
Um, Thank you very much, Ilham, and thank you for the question. I think the principles laid out in Halliburton, impartiality, disclosure, those are immutable principles which any practitioner, whether as a practitioner or as an arbitrator, must ascribe to. And in that sense, therefore, Halliburton merely restated and extended those principles to a situation of repeat appointments. When you think about any civilized nation ascribing to the rule of law, you ascribe to the expectation that whether it is a judge or an arbitrator, the judge or the arbitrator will be impartial. And the question of impartiality necessarily encompasses a responsibility to make disclosure so that the parties can make informed decisions as to whether you should continue to preside over the determination of that dispute in order for the outcome to be accepted and respected. And that is the way in which the rule of law is promoted. And so it seems to me, therefore, that Halliburton just presents a template that we should be borrowing from and that should be enabling us to propel ourselves forward. I hope that I have sought to answer the question.
Thank you, Mr. Haga. Can I turn to Professor Ajayi, taking your opposition hat off? What's your take on this question? Should there be a greater duty of disclosure than that in Halliburton in Africa?
I think not, and I'll tell you why. Seriously speaking, the African market is not mature, and it's truth be told, shallow. And therefore, we cannot expect the same measure of disclosure as you would expect in England, where the rules and the market is highly developed. I think it is also very important to bear in mind where the case landed. We've seen what was said in Halliburton, and when you see how it was applied in Newcastle against Premier League, you see how exacting the standards could be on the one hand, and how one can say there is a defaulting or a defective combustion engine at play, because you read the reasoning and you begin to think, should that be the and so that is why I would say let's sit back again and look at this decision. The decision, yes, I would say supports what the African market should hold, but then we've got to look at the reasoning, because it's not the decision that we're applying. We're looking at the reasoning. And when you look at the reasoning, you begin to question what it really does. Yes, there must be the rule of law. Yes, we must ensure that justice is done. But the question is, what should be the level of disclosure? Now, I am sure that many in the audience that are from Nigeria, or people that know of the cases that come out of Nigerian courts, would have heard of Global Gas and Refining Limited against Shell, where the court said that once a party raises his hands, the arbitrator should resign, right? So you begin to see how at times, when we look abroad to borrow, we get it totally wrong, because it cannot be right. This same judge cannot, in cases before him, hands off a decision simply because someone says, oh, there's a problem. The judge is expected to go through the process, and there are clear principles that are applied in determining whether a judge should recuse himself. Thank you.
Thank you, Professor Ajayi. We have another question. It's quite an interesting one, and I'll put it first to Mr. Ohaga and then to you, Prof. When the Supreme Court considered the duty to disclose, it looked at the appearance of bias from the reasonable man test. However, a number of arbitration rules look at it as a duty to be assessed through the eyes of the parties. What's your take on that, John? Eyes of the parties, reasonable man test. What would be the recommendation in African jurisdictions?
Yeah, that's an interesting question, Ilham. I have to confess that on that, I part ways with the Supreme Court. You cannot at once accept or propound the proposition that arbitration is contractual between the parties and then suggest that the consideration should be that of the reasonable man. It really has to be that of the parties, because it is the parties who are interested in the outcome. It is their subject matter. The arbitrators are their choice, or the mechanism that they have put in place to choose the arbitrator. And so therefore, in that sense, it is limited to the four parameters, the walls in which those parties reside or have confined themselves, that arbitration room. And to expand it, therefore, to the reasonable man is to take it outside the ambit of the contract and to invite into that contract a consideration which the parties did not have in their contemplation when they framed their arbitration agreement. And so on that, my view is very firm, that I think the arbitration institutions are right when they frame it as limited to the parties rather than the expansion which the Supreme Court took into consideration. Thank you.
Thank you, Mr. Ohaga. Professor Ajayi, would you share Mr. Ohaga's firm view on the question? Grateful for your thoughts on this.
Thank you. No, thank you, Mr. Ohaga. I told you the really behind him supports my proposition. Thank you for that. I agree with him. Absolutely. Nothing to add.
Okay, then that leads us to the last question I will take from the audience before turning to the poll and saying which one of the debaters has swayed some of the participants one way or the other. It's a question on ethical considerations. And what is the ethical consideration on the principles of impartiality, confidentiality, and disclosure? Should the African markets aspire to be on the same ethical level that in other advanced economies? So we're speaking ethics now. Professor Ajayi, do you want to go first?
Yeah, I'm glad to. Ethics is a matter of philosophy and society, and therefore we clearly cannot apply the same standards. I agree that there are international minimum standards of conduct and of what is right. There's certain minimum standards of what we expect. There are things we expect of judges in terms of impartiality and fairness, and that really must be our focus. Secondary things as to how many people I work for, how many people I relate with, I think needs to be considered in another bucket. We must know that every society has a longitudinal approach to values. It's a longitudinal approach to values and begins to rise as society itself rises. So yes, ethics has a good role to play, but I don't think the standards can be the same simply because our markets are different. As I mentioned, in the United States, in the United Kingdom, OECD countries, you had tons and tons and tons and tons of arbitrators making lots and lots and lots and lots of money. And therefore, the rules by definition, have to follow the pattern of the market. And I think we need to fashion rules that follow the pattern of our market.
Thank you, Professor Ajayi. Mr. Haga, some final words on that question?
Yes, I think when you think about it from the perspective of international arbitration, then you have to accept that there must be a common standard that we seek to impose on arbitrators. You cannot have one standard that relates to a party from Kenya and a different standard that relates to a party from Egypt when you contemplate that these parties may engage in a contractual relationship and may end up in arbitration. There must therefore be some uniform standard that you would be looking to. And Professor Ajayi says that ethics is a question of philosophy, and I have to agree, but I think that it goes beyond that. I think every society recognizes at some point principles of honesty, fairness. It may be the question of degree, but the existence of those principles is recognized in every society. And so therefore, there must be a way in which we can have a standard that would apply in international arbitration without having regard to particular cultural norms or particular standards in different societies, or excusing an arbitrator's lack of disclosure because they come from a society where the standard is lowered, or complaining that the standard is required is too high because the arbitrator comes from a jurisdiction where there is a lower standard. So I think it is the search for that standard that we are seeking to determine here. So it is about, from an ethical consideration perspective, it is about honesty, it is about fairness, it is about openness. And I see disclosure as the antidote to any potential complaints relating to conflicts of interest.
Thank you, Mr. Haga. And I have one last question to both of you, and that one is also to give you an opportunity for some closing remarks before we do the last poll, and I hand over to Laciac to close. So you both spoke about the importance of having rules tailored to the market and to the different African markets. So I have a question that was submitted before the event, and that question came from Abayomi Okubote. What is your take on having African standards in respect of the duty to disclose? Should those be developed? And if so, at the continental level, at the regional level? Professor Ajayi, what's your take on that?
I think as we have the African Continental Free Trade Association, as we've got the African Union, we should, as they have in Europe, gone from just a commission to a union, do the same thing in Africa, and begin to develop our standards that are continental. Now, it will be useful if these things are building blocks. So we can, for instance, we know we have a common standard with OHADA, which is the French-speaking countries, and that's very easy. With the common law countries, it's slightly more difficult, but there is a lot in common. And so it's either we build blocks by way of our regional associations like East African, Community of Nations or West African Country Nations or COMASA or whatever. But I have no doubts in my mind that Africa must develop its standards that would be developed by its people and developed for its market. The American standards are not exactly the same as the European standards, which are not exactly the same as those of the United Kingdom. So to my mind, we must do these things. And I know that there are initiatives by the AU with respect to other things in trying to come up with common standards within the continent.
Thank you, Professor Jai. Mr. Ohaga, what are your views on building blocks and trying to get more uniform standards?
I accept that we must get uniform standards. I have to confess that I'm very reluctant to propose African standards, because it seems to me that the suggestion of African standards necessarily then limits the arbitration market to Africa and African parties, because it necessarily, especially if those standards are standards that would be considered of a different nature or different from the standards that we would otherwise find in jurisdictions which have developed the arbitration markets to a certain level. But the moment we start to talk about international arbitration, we must recognize that there is investment into Africa by Chinese, Japanese, Germans, the Nordic countries, and they necessarily, or we would like that in relation to their contractual arrangements in Africa, that those arbitrations could be determined in Africa by African arbitrators. But they have to be standards that they themselves, as parties investing into this continent, will understand and ascribe to. And therefore, I'm very hesitant to talk about African standards. If we go on to suggest that those standards then will be perceived as a lower standard, I would suggest that in seeking to establish standards, we must look to what would be considered best practice internationally, and that best practice then becomes the African standard. And so we are at the level where parties coming into our continent would freely, confidently agree that the Nairobi Center for International Arbitration, for instance, could be the institution that provides the mechanism for the resolution of a dispute between a Chinese party and a Nigerian party contracting in Kenya. That is the way that I perceive it.
Thank you, Mr. Ohaga, and thank you to both of you for taking on your role really seriously and engaging with the audience on the questions and comments following the debate. So now it's time to see how persuasive you've been and whether you've been able to sway our participants in one direction or the other. Titilope, can I ask you to hold a second poll so we can see what's our participants' position at the end of the debate? So we'll give all of you 1 minute to vote. As the moderator, apparently I cannot vote, but I will say that I will choose Mount Kilimanjaro over the dark caves of Wales any day. Okay, it's been 1 minute on my clock. Can we see the results? Oh, Professor Jai, you have increased the percentage of no's, which went from 9% to 24%. And Mr. Ohaga, we were at 38%, if I'm not mistaken, at the beginning, going up to 39, and we have more indecisive people at the end than at the beginning. So I guess this debate was a success. And with this last comment, I will hand over to Laciac to close. Thank you to the debaters and thank you to the participants. You've made this event a success.
Thank you very much, Ilham. Thank you for your rich moderation. Thank you for the opportunity to participate in this debate. Thank you very much, Professor Ajayi. I've learned a lot from you. I will visit Mount Kilimanjaro again.
Well, thank you very much. I mean, I think this has been great. And clearly, there's a lot that, to draw from the bottom of the mountain where I left people, as you said. But honestly, I think this, I must thank the organizers for giving us the opportunity and for our excellent moderator for keeping us honest and, dragging us in different directions and, making life absolutely difficult for us, doing to us what we do to people in court. You are cross-examining us without, letting us know what you were doing. I think at the end of the day, what we see is that Africa is rising. Thank you. Thank you, everybody. Thank you.
Thank you very much, everyone. Thank you so much for, we have, at the moment, we have 65 persons, including the panelists on board, that we have kept this many people engaged and on board for this long. I must commend us. Thank you very much. It means that our debaters and our moderator have been absolutely engaging, and we thank you all very much. As expected from the line of participants, it's been an interesting and insightful session. And again, I commend the debaters. Mr. John Ohaga, SC, thank you very much. Professor Kwansala Ajayi, Senior Advocate of Nigeria, thank you very much for thoroughly dealing with the issues. And our moderator, Ilham, for steering the ship in the right direction and maintaining such an even keel. Oh, fantastic. Thank you very much. So we're also grateful for our audience, participating all those questions and kept the debate lively. Thank you all very much. And we look forward to seeing you again at the next edition. I'd also like to use this opportunity to invite our audience to take part in some of Laciac's other initiatives, such as the Africa Energy Arbitrators Forum, the AEA we call it, which was recently launched. The AEA is organized by Laciac and supported by the School of International Arbitration, Queen Mary University of London. And its mission is to promote better dispute management and resolution in Africa's energy projects. In September 2021, the AEA will host an exciting and practical training course for dispute practitioners who wish to pursue opportunities in energy arbitration. Participants at the AEA preliminary module will gain practical training in the management and resolution of energy disputes using case studies inspired by real-life situations. And they'll have the opportunity to participate in a competition with a chance to win sponsored internships with international law firms. And then they'll also gain career guidance by leading experts in management and resolution of energy disputes. High performers in the AEA preliminary competition will be recognized in Laciac's list of energy dispute experts. A link will be shared in the chat box. This is Lope. To provide more information on the AEA, we urge you to follow us on LinkedIn and to ensure that you are up to date with our events and initiatives. I cannot thank you enough. God bless you, and please join us for the next edition of the Laciac Live Debates. Thank you very much. Bye, everyone.
Thank you. Bye.
Thank you. Bye-bye.